What is the standard of proof in a criminal case?
In criminal cases, standard of proof is beyond a reasonable doubt. It's hard to quantify that. In civil law, it's 50-50, 51-49. That's kind of the margin. If you're slightly over that, you're there. In criminal law, that's not enough. It has to be beyond a reasonable doubt. In percentage terms, you'd be talking 80s to 90%. It doesn't mean there can be no doubt. It just means that as far as the judge is concerned, or the jury, there's no reasonable doubt. But it's a very high standard to reach. It's much, much higher than the civil law jurisdiction.
Which standard of proof is required in all criminal cases?
The standard of proof in all criminal cases is beyond a reasonable doubt. That's the standard of proof in criminal cases in every democracy around the world. And there's a reason for that. Because if the case is to be made out against you, the sanctions are severe. The sanctions, if a case is made out against, if you lose a criminal case, the sanctions could include jail. And every democracy, every constitutional democracy takes the view that jail as a sanction is the ultimate sanction, just short of death. So if you're going to send someone to jail, you really have to be sure, very, very sure. It's not a kind of a flip of a coin, you must be sure. And that standard is beyond a reasonable doubt. There can be no reasonable doubt in your mind as a judge before you sentence a person.
Why is the standard of proof higher in a criminal case?
It's higher in a criminal case because in a civil case, if you lose, you just lose. And yes, you pay costs. It's a monetary penalty to you if you lose in a civil case. In criminal cases, the reason why there's a higher standard is because if you lose, there's a very real risk of jail. And judges tend to think in terms of weeks, months, years. So you'd have a long time in jail thinking about what went wrong. So for a judge to kind of make that decision to deprive someone of their liberty, which is what jail is, they have to be very, very sure. And that's why it's much, much higher than civil law.
What is the standard of proof in a civil case?
In a civil case, it's much less lower. Much lower than criminal law. Criminal law is very high. Civil law is much lower. It's 51-49. You can actually quantify it in percentage terms. If it's more probable that what happened, and you're on that side of the argument, then you'll win. It's the preponderance of evidence. If the preponderance of evidence suggests that your argument should prevail, then it will prevail. It's more likely than not to have happened, then you succeed. But it can be condensed into percentage terms. It's 49 versus 51.